Alright guys, the history of equality in Canada. We're just going to get right into it. So, the Canadian history of equality. This section situates the development of equality law with Canada's broader history of colonialism and systemic exclusion. Yeah, so essentially we're going to be talking about some inequality first of all. So, again, since Confederation in 1867, Canada entrenched policies that subjugated Indigenous peoples. The Indian Act institutionalized control over Indigenous identity, governance, culture, and movement. The Indian Act facilitated policies that contributed to cultural genocide, especially residential schools, forced assimilation, etc., etc. And poor treatment of Indigenous people have persisted until today. Voting rights were a marker of exclusion. Post-Confederation, we've seen several different benchmarks for inclusion following periods of exclusion. So, again, all these different people groups that we're about to talk about, they were all excluded from being able to vote, and we've slowly seen them gain that right. So, women, specifically white women, in 1920 were granted the federal voting right. Japanese and Chinese women were excluded until 1947, where they eventually gained voting rights, and Indigenous people couldn't vote until 1960 unless they relinquished their Indian status. So voting, we can use voting as a marker of exclusion. It has a lot of historical basis. Again, white women specifically granted rights to vote in 1920, Japanese and Chinese Canadian women in 1947, and Indigenous people in 1960. Unless they relinquished their Indian status earlier, which made a point of demonstrating that formal citizenship was conditional for them. Disability discrimination in the 20th century, naturally that continued to exist. There were involuntary sterilization laws in Alberta and BC in the early to mid to late 1900s. Forced sterilization, involuntary sterilization for people with disabilities. So that's our dark turn, our key history of inequality. Again, colonization and subjugation, voting rights, which were slowly granted, but we can use as a marker of exclusion, and disability discrimination and forced sterilization until the 20th century. Then we get into the development of equality law in Canada, right? When do we really start turning into the good guys? It was slow and it was uneven, but it happened. So before the 1940s, there was zero legislative protection against inequality or discrimination. Discrimination was considered normal, especially in things like employment, education, and housing. But after World War II, due to the Holocaust, there was a huge global human rights movement. We saw a huge boom in equality law. And then in 1948, we got the Universal Declaration of Human Rights. Article 1 of that said that all human beings are equal in dignity and rights, and Canada, as a UN member, came under new and normative pressure to align their domestic law with the new international standard. 1947, we saw the Saskatchewan Bill of Rights. This is a predecessor to the Canadian Bill of Rights in 1960, and this 1947 Saskatchewan Bill of Rights was the first provincial Bill of Rights in Canada, symbolically acting as a pioneering provincial step, but naturally it was limited in enforcement mechanism because it wasn't federal. 1960, passed by Parliament Prime Minister John Diefenbaker, we got the Canadian Bill of Rights, which recognized equal protection under the law, but it wasn't constitutional, and it only applied to federal laws, not provincial laws. So there's still some error in enforcement, and it could be overridden by subsequent legislation. Equal protection is the right not to be discriminated against, to be treated equally in the face of the law, etc., etc. That's what we're looking at when we say that the Canadian Bill of Rights recognized equal protection. Again, the first Canadian Bill of Rights recognized this right to not be discriminated against and to be treated equally. The thing is, the 1960 Bill of Rights, the Canadian Bill of Rights, was more of a formal equality as opposed to substantive approach, where the 1977 Human Rights Act, which we're going to look at, right now actually is more substantive. So the 1977 Human Rights Act is a federal statute providing federal protection, prohibiting discrimination on various grounds in areas under federal jurisdiction, things like employment and other services. We'll talk about this a lot later, but it was really more practical than symbolic, establishing tribunals and remedies for confronting discrimination. So again, we had pre-40s no equality legislation. Post World War II, we got a huge boom in equality law with the Universal Declaration of Human Rights in 1948 and Canada's involvement in the UN kind of having an effect on us. Then we got the Saskatchewan Bill of Rights in 1947, limited due to only being provincial. Then we got the Canadian Bill of Rights in 1960, which was limited because it was only federal and it wasn't constitutional, but it recognized equal protection under the law, which means you have a right not to be discriminated against and to be treated equally. Then we got the Canadian Human Rights Act, the federal statute providing federal protection, prohibiting discrimination on various grounds in areas under federal jurisdiction. Again, like we said, it's more practical than symbolic since it established tribunals and remedies for confronting discrimination. That's important. That's what the Canadian Human Rights Act got us. Then in 1985, we got the Canadian Charter of Rights and Freedoms. Entrenched in the Constitution for Canada, the Canadian Charter made equal rights supreme law. The codifying of these equality rights in our Constitution was major. Primarily, Section 15 in the Charter guarantees equality before and under the law and equal protection and benefit of the law without any discrimination. The introduction of the Charter marked a shift from symbolic recognition to binding constitutional protection. It prohibited discrimination on the basis of enumerated grounds and ultimately acted as a huge step towards the equality that we see in Canada today. By the 1980s, there was a conceptual shift of how equality was understood from being formal to substantive. Shepard, like we talked about earlier in a last lecture actually, really underscored this evolution. So again, a shift in understanding here. We can see a shift from viewing discrimination as predominantly an individual problem to being more complex and institutional. We saw a focus on discriminatory attitudes from individual perpetrators to a focus on the experiential effects of inequality and exclusion. We saw a shift from viewing discrimination as differential treatment to acknowledging adverse effect discrimination resulting in the different effects of apparently neutral policies and similar treatment on different kinds of people. We saw a shift from individual remedies to systemic remedies and institutional transformation. We saw a shift from understanding problems of discrimination in terms of distinct homogeneous social groups to recognition of overlapping inequalities linked to complex, intersecting, and multiple identities. Basically, we saw a shift from being much more formal in our approach to equality to much more substantive with structural shifts, systemic and systematic perspective changes, etc., etc. Implicitly, in 1960s and 70s law, discrimination was defined as group-based harmful treatment or exclusionary-based negative stereotypes. Discrimination was considered to be discrete acts that could be redressed retroactively in a claims process. Substantive equality attempts to place provisions that can stop discrimination in the first place. By the 1980s, equality and discrimination became much more understood than simply group-based harmful treatment that was more discrete that you could then later address with a claim. Alberta's equality law development. So we saw a short progression here. In 1966, got the Alberta Human Rights Act. Again, Alberta Human Rights Act predated the Canadian Human Rights Act. Remember, Canadian Human Rights Act is 1977. The Alberta Human Rights Act is 1966. It was our first provincial step as a province to human rights legislation. Alberta was the third province to enact anti-discrimination legislation, again, before federal constitutionalized Human Rights Act. In 1972, the Human Rights Act in Alberta was replaced by the Individuals' Rights Protection Act. Both are early frameworks that attempt to extend protections, but with limitations. In contrast to the Human Rights Act, this act got primacy status, saying that all other laws in Alberta had to align themselves with it. So, essentially, the benefit of the 1972 Human Rights Act, or the 1972 Individual Rights Protection Act in Alberta, is that all other legislation that came or existed had to align itself with the provisions set out in the Individual Rights Protection Act. That is primacy status. And then in 2000s, we got this kind of new Alberta Human Rights Act. It applies to both provincial government action and private sector conduct. This dual application reflects how equality law has expanded beyond the state to regular society-wide practices. So again, our equality development as a province, 1966, we got our first Human Rights Act, very provincial, had the same limitations as Saskatchewan's that we talked about earlier. 1972, that Human Rights Act was replaced with the Individual Rights Protection Act. This was much more progressive. It also got primacy status, which means all of the legislation had to align themselves with it. And then in 2000, we got the Alberta Human Rights Act, which is our current legislation, and it applies to provincial government action and private sector conduct, emphasizing the equality regulation over society-wide practices. Yeah. Some insights from the PowerPoint. Again, law is reactive in nature, so equality law in Canada consistently lagged behind social movements and injustices, only changing after external pressure. For example, change norms post-World War II, Indigenous activism in the 60s and 80s, 60s to 80s. Equality law in Canada had a layered development, so instead of a single leap towards equality, it came in stages, right? Provincial initiatives to federal statutes to constitutional entrenchment. Each step kind of increased the scope and enforceability of equality law rights. Our law for equality moved from symbolic to much more substantive. In the the early protections, 1947, 1960, these were very much symbolic, right? Like the Saskatchewan Bill of Rights, the Canadian Bill of Rights, again, much more symbolic because it wasn't constitutional. The Bill of Rights specifically, it wasn't constitutional. It recognized that equal protection, but it only applied to federal laws, not provincial, and it could be overridden by subsequent legislation. But then later on, we started to get something more codified, especially when we saw things like the Charter and the Canadian Human Rights Act, and these were huge leaps and bounds. Yeah, it became by 1982 to 85 much more binding and enforceable. Naturally, despite all this, systemic inequality still persists, especially in the realm of Indigenous equality. Law can be a tool for progress, but it has also been historically a tool of oppression. All right, that's you know what? We'll combine that with this this next topic, since it's also not too bad. So consider all of that history, and now we're really gonna elaborate. Okay, so now we can get into the constitutional and legislative equality protections. So the objectives to this, since it's much more expansive, is to determine, at least from our perspective, consider how formal and substantive equality are applying to different pieces of legislation that you see here, but really just kind of remember that from earlier topics. What does it mean? We're going to look at enumerated grounds of protection under the Charter, and what does it mean when we say that they are expansive and not exhaustive? What is the significance of the Charter in comparison to the Bill of Rights? What is meant by the need for a comparator group in things like formal equality, and what are some of the challenges with this? That has to do with that original topic, our first lecture. Same as why was dignity used by the courts and what are some challenges with it? We're going to look at that here too. How do judges' understandings of equality relate to their conception of the roles and responsibilities of government, and what is meant by reasonable limits? These are kind of our objectives for now that we're really expanding on the earlier concepts. So feel free to look at the screen. I'm going to take a sip of water. Yeah, look at the screen, get the objectives in your head, and then as we go through them, think about them. Okay. So, one, constitutional protections, okay? We're going to look at the Bill of Rights, we're going to look at the Charter, we're going to look at a lot of development there. We're going to look at the Constitution Act of 1982. Yeah, alongside the Charter. So these are going to be our constitutional protections. So the Bill of Rights, Section 1B, recognizes the right of the individual to equality before and under the law and equal protection of the law without discrimination based on race, national origin, color, religion, or sex. The nature of the Bill of Rights was to be enacted as a federal statute, not a constitutional amendment. So the thing is, when it comes to the Bill of Rights, despite not being a constitutional amendment, it was considered quasi-constitutional, meaning that it had elevated status compared to ordinary legislation. But again, it wasn't entrenched like we'll see the Constitution is. The Bill of Rights can be directly amended or repealed, though difficult, unlike the Charter. Yeah. So how was the Bill of Rights interpreted judicially? Courts took a very narrow and a formalistic approach, often limiting the effectiveness of the bill, at least initially. But because of that precedent, it's rarely relied upon today. Naturally, with the Charter taking precedence and the kind of the Bill of Rights being implemented into that. Some key cases that we looked at: Bliss versus Attorney General of Canada. I won't get into the details, but essentially that led to the acknowledgement of pregnancy discrimination as a form of sex discrimination and set the precedent for it. Yeah. And then we saw Brooks versus Safeway, which was a later case under human rights law, where the pregnancy discrimination argued for in the Bliss case was finally recognized, showing progress beyond the Bill of Rights. Yeah. A textbook insight is that this period, the period of the Bill of Rights, again around the 1960s, reflected formal equality, and we see that in the Bill of Rights too. This idea that like cases can be treated alike, and so courts focused on identical treatment, ignoring different outcomes for disadvantaged groups. This reinforced inequality as opposed to remedying it. So the Bill of Rights, as a piece of legislation, most of its legacy lies in the fact that it set the groundwork for things like the Charter, but again, the fact that it was a federal statute that wasn't constitutionally amending, but it was quasi-constitutional, so it had elevated status. But it can be appealed, but the judges took a kind of narrow, formalistic approach. It all just kind of isn't really relied upon too much. But Section 1B of the Bill of Rights recognized the right of the individual to equality before and under the law and equal protection of the law without discrimination based on race, national origin, color, or religion or sex. Then we move in to the Charter of Rights and Freedoms. This is Big Daddy. This is Big Daddy for Canadian equality law. So the Bill of Rights guaranteed the same rights as the Charter. However, the Constitution, which we'll talk about, the Constitution, which was patriated in the Constitution Act of 1982 and introducing the Charter, constitutionalized equality rights. So the Charter and the Constitution technically constitutionalized equality rights. Following this, the courts also emphasized that the purpose of the law and the context in which it was created is crucial. This is the purposive approach and the contextual approach. And this is important when we're interpreting the Charter. So a purposive approach is thinking about what the intent was at the time that the legislation was written and applying the law that way. A contextual approach is thinking about the current context and applying the legislation to it through a modern perspective. Okay, so let's dig into the Charter. Section 15.1 of the Charter guarantees equality before and under the law, as well as equal protection and benefit of the law, without discrimination on grounds such as race, national or ethnic origin, color, religion, sex, age, disability. Section 15, subsection 2, allows for affirmative action programs designed to ameliorate conditions of disadvantage within groups without being considered discriminatory for favoring certain other groups, right? So when we were looking at equality of outcome, that was one of the concerns, right? This reverse discrimination. The features of the Charter, what does the Charter have with it? It has a list of protected enumerated grounds. That's a big term in the class, right? Enumerated grounds. And this list in the Charter of Enumerated Grounds is expansive and open-ended. That means that it's not exhaustive. So, enumerated grounds are not meant to be exhaustive. First, what are enumerated grounds? Enumerated grounds are grounds of discrimination that are codified into the legislation, unchanging. They are always grounds for discrimination, and these grounds are not meant to be exhaustive, meaning you can argue that you were discriminated on not necessarily included grounds and argue for that form of discrimination to be included in discrimination law. Um, yeah, so that's we'll get into this later, but starts getting into the concept of analogous grounds. So we have our enumerated grounds. These are grounds that are unchanging, codified, uh, not meant to be exhaustive, but they are open ended, so they can be added to a degree. I think I keep saying not changing. My bad. They can be changed to the extent that the analogous grounds can be added to them, or at least considered in reference to them. But the point is that these enumerated grounds cannot be removed. They're codified. They're there. Um, yeah. So again, the list of protected enumerated grounds in the Charter is expansive and open-ended, so it's not meant to be exhaustive, not meant to be absolute in its restrictiveness. Okay. Um, Vriend versus Alberta was a case that we looked at here. So that's where the court read sexual orientation into Alberta's human rights legislation after omission was found discriminatory. So again, sexual orientation is an analogous ground, right? Just so I can be absolutely sure. Yes, yeah. Anywho, we'll get into that, and we'll have the full list of analogous grounds and things like that. But yeah. So we have our enumerated grounds. We have our analogous grounds. Uh, the limitations of the charter. Um, yeah. So Section 1 of the Charter allows reasonable limits. We also consider this to be the limitations clause, saying essentially rights are not absolute, but must be balanced in a free and democratic society. The limitations clause in and of itself. Let's get the exact definition here. The limitations clause permits the government to impose reasonable limits on rights and freedoms of its restrictions if the restrictions can be justified in a free and democratic society. So again, the limitations clause, section 1 of the Charter, allows the government to impose reasonable limits on rights and freedoms if the restrictions can be justified in a free and democratic society. This is technically a limitation of the Charter because, again, we get to suspend rights as long as it's balanced with the free and democratic society. But yeah, anyway, that's our charter. Broad understanding of the charter. Doctrinal development. So this is kind of our some of our case law here. Andrews versus the Law Society of BC. Big Section 15 case rejected similarly situated tests. This case defined equality in terms of effects, meaning discrimination equals laws that impose burdens or deny benefits based on group membership. So this is the case. This case saw the official recognition and defining of substantive equality in its initial stages, and it established protection against direct and adverse effect discrimination, with direct being explicit distinction and adverse effect being neutral laws with harmful impacts or indirect discrimination. We also saw Law v. Canada. We talked about that, but in this case, the context here that's important when it comes to substantive equality is that Law v. Canada introduced a 3-part test that was implemented into legal framework for assessing violations of substantive equality. Later, it was criticized for being too vague, but the judicial 3-pronged doctrinal test for evaluating laws, in contrast to Section 15 of the Charter, under the guise of substantive equality, is A, does the law impose differential treatment based between the claimant and others? 2, is the differential treatment acting against an enumerated or analogous ground listed in subsection 15? as a protected ground or a similar ground? And 3, does the law in question have a discriminatory purpose or effect? Again, the judicial three-pronged test for evaluating the law in accordance to Section 15 of the Charter, introduced in Law v. Canada, was: does the law impose differential treatment between the claimant and others? Is the differential treatment acting against an enumerated ground or analogous ground listed in Section 15 of the Charter, or a similar ground? And does the law in question have a discriminatory purpose? If yes to these, then the court must consider, can this discrimination be justified in a free and democratic society? No, then the law isn't allowed. Yeah. We have some cases here. Not entirely too important. A good example of the three-pronged test was this case, Eldridge versus BC. A deaf claimant argued that Medicare's failure to provide sign language interpreters created unequal access to health care. So the court found, in accordance to the prongs, that the legislation, in accordance to differential treatment, yes, the lack of interpreter impaired their ability to properly communicate with doctors and so increased their risk of ineffective treatment. According to protected grounds, yes, physical disability was being acted against as a protected ground. And discriminatory purpose, no, the Medicare system was for the general population. It wasn't necessarily discriminatory in purpose, but there was a question posed. The BC government provided no evidence to show that the provision of interpreters would place strain on government financial sources. So why not do it, right? Why not just mend the situation? But yeah, that's a good example. In the case of RV Cap, this three-pronged test, because remember it was criticized for being too vague. This three-pronged test, it was simplified into a two-part test. Does the law create a distinction between enumerated and analogous grounds, and does it create disadvantage by perpetuating prejudice or stereotyping? If yes to these, then the court must consider, again, does the discrimination, is it justified in a free and democratic society? No, then the law isn't allowed. Both of these tests recognize differential treatment and similar treatment with unequal effects can be discriminatory, and they both recognize that equality analysis requires looking at context, history, and effects of laws, context, circumstances, and treatment, not just surface level fairness. So, again, right now we've gone through the Charter, Section 15, 1 and 2, that allows for affirmative action and guarantees equality under the law. We talked about the fact that the Charter has a list of enumerated grounds that are expansive and can be added to analogously. We talked about the limitations clause, some case law, the three-pronged test for evaluating discrimination in accordance to Section 15 of the Charter as far as legislation goes, introduced in Law v. Canada, and a two-pronged test in RV Cap that was used to simplify that. Other sections relevant to equality, Section 25 says that the Charter cannot derogate from Aboriginal or treaty rights, and Section 28 guarantees all Charter rights are equally held by men and women. Some textbook insights. Textbook says that within the Charter, the court's perspective shifted from formal equality to substantive equality. We mentioned this lightly. But it was recognized that identical treatment can still harm disadvantaged groups. Substantive equality requires assessing outcome and context. The courts also moved towards the perspective of having a comparator, not simply formal equality and treating everyone equally, at least under the guise of substantive equality. So they essentially said that equality analysis should not be narrowed to a competition between socially disadvantaged groups. The analysis of the exclusion should remain rooted in the larger comparative dimension of inequality. Important thing there is just the court's perspective shift from formal equality to substantive equality. When interpreting the Charter in the face of equality, the courts articulated their purpose as redressing historical social disadvantage and respect for human dignity. That's why they were interpreting the Charter. There's an internal contradiction in the Charter. The Charter says everyone has equal rights, but the real idea is to help people who faced historical disadvantage. Through a purposive perspective, we'd say that the purpose of the Charter was to remedy historical discrimination, and therefore people that hadn't faced it can't abuse the legislation laid out in the Charter. As far as the Charter goes, human dignity was emphasized as integral to the interpretation of equality. However, due to dignity subjectivism, it could provide an additional hurdle for the system. As such, the court doesn't really look at dignity as integral to the equality process. And finally, group-based rights and identity politics are complex issues. We need to focus on how law can recognize group-based differences while being attentive to the risks of essentialism and defining of groups while potentially excluding other members of groups that don't fit into that definition. The law tries to create fixed categories, but that doesn't really work with dynamic identity, and we have dynamic identity, so we need to keep that in mind. Yeah, that was our textbook insights there. So that is our Charter of Rights and Freedoms. Yes. So we've gone through the Bill of Rights, we've gone through the Charter of Rights and Freedoms. Let's look at the Constitution Act. The Constitution Act of 1982, Section 35. So Section 35 of the Constitution Act recognizes and affirms the existing Aboriginal treaty rights of Indigenous people. Section 35, subsection 2, defines Aboriginal people as including First Nation, Inuit, and Métis, and Section 35, subsection 4, explicitly guarantees these rights apply equally to male and female persons. So essentially, the Constitution Act here goes beyond the Charter by constitutionally protecting Indigenous rights and embedding gender equality within them. Okay, so those are our constitutional protections, right? The Bill of Rights, Constitution Act, Canadian Charter of Rights and Freedoms. Let's look at some legislative protections. So we're going to look at the Canadian Human Rights Act, we're going to look at the Alberta Human Rights Act, and then we're going to look at a couple other things. But the Canadian Human Rights Act, 1977, it applies to federally regulated sectors, right, like banks, telecom, transportation. Section 2 in it says that all individuals have an equal opportunity to build their lives with accommodation of needs where appropriate. The Act protects against discrimination practices on the ground of one or more prohibited grounds of discrimination as per Section 35 and 25 of the Act. So the grounds of discrimination, these enumerated grounds: race, national ethnic origin, color, religion, age, sex, sexual orientation, gender identity expression, marital family status, genetic characteristics, disability, and pardoned convictions. All of these are now enumerated grounds that we have here. We'll talk about these later in a different lecture, I think. But yeah, that's our Canadian Human Rights Act. Again, applies to federally regulated sectors, so that people have an equal opportunity. People deserve an equal opportunity to build their lives, and it protects against the discrimination against enumerated grounds like race, national ethnic origin, color, religion, age, sex, sexual orientation, gender identity, marital status, genetic characteristics, disability, pardoned convictions. These are the grounds of discrimination in Section 3 and Section 25. I don't actually know if they are the enumerated grounds. Let me see if I just have a list of every single enumerated ground. Feel free to grab some water as I take a second break. Okay, so enumerated grounds, as far as I can tell, the enumerated grounds are race, gender, religion, and sexuality. So, Section 3 and Section 25 just present grounds for discrimination: race, ethnic origin, color, religion, age, sex, sexual orientation, gender identity, all these things. These are all grounds protected in Section 3 and Section 25, and that's what the Canadian Human Rights Act protects against. And the enumerated grounds. Our enumerated grounds are this is what I wanted. Sorry about this. Race, national or ethnic origin, color, religion, sex, age, and mental or physical disability. These are our list of enumerated grounds. Anywho, I know that was a long pause. I deeply apologize. Just as a quick little recap, that was the Alberta Human Rights Act. So we're looking at our legislative protections now. That was our Alberta Human Rights Act. It applies to federally regulated sectors. Section 2 of it says that all individuals should have an equal opportunity to build their lives, and with accommodations where need be. The Act protects against discrimination practices on the grounds of one or more prohibited grounds of discrimination as per Section 3 and 25. This includes race, national, ethnic origin, color, religion, sex, sexual orientation, gender, identity, expression, etc., etc. All of these, many, many things. Okay. Now, let's look at the Alberta Human Rights Act. So that was the Canadian Human Rights Act. Let's look at the Alberta Human Rights Act. The Alberta Human Rights Act, its preamble recognizes inherent dignity and equal rights as a foundation of freedom, justice, and peace. If you look at the screen, the preambles are here, but I don't think we need them. Essentially, the Alberta Human Rights Act is just recognizing inherent dignity and equal rights as foundation for the country. It protects against discrimination in areas like employment, housing, and services, on grounds including race, religion, gender, disability, etc., etc. Other federal and provincial statutes include the Employment Equity Act of 1986, requiring federally regulated employers to take proactive measures to improve workplace representation for marginalized groups. This is a federal legislation. The Accessibility Act in Canada, 2019, aims for a barrier-free Canada by 2040, addressing accessibility in federal jurisdictions, recognizing that laws, police, and all these different kind of structural components must recognize the different ways people interact with their environment by disabled and marginalized peoples. It's essentially, the Accessibility Act is just about making our world more accessible. Bill C-65 amended the Canadian Labour Code to better address workplace harassment and violence. Provincial anti-racism laws we see in things like Ontario, BC, and Nova Scotia that have explicit anti-racism legislation. Alberta doesn't have one of those, but these are all of our different kind of federal, provincial statutes as our legislative protections, as opposed to simply our constitutional protections. So again, our legislative protections, we add that Canadian Human Rights Act, the Alberta Human Rights Act, and then some other things. That's going to be pretty much it for this topic. Yeah.